Good morning, everyone. My name is Lee Paddock. I'm the Managing Director of the International Network for Environmental Compliance and Enforcement. We welcome you to today's program. INES is an organization that's been in existence for about 30 years, connecting enforcement officials around the world. We have networks in the Americas, Red Lafika, in Australia, in East Africa, and in Europe, and provide capacity building and information exchange to support environmental enforcement. Today, during the webinar, you'll have an opportunity to submit questions for our speaker, and you should do that utilizing the question and answer box in Zoom. So please use the question and answer box. The chat will be disabled because it's more difficult to manage questions with the chat. Our speaker today and the conversation we're going to have is with Cynthia Giles, who is a long and distinguished career in environmental enforcement, beginning with the U.S. Attorney's Office and with the state of Massachusetts, and during the Obama administration as Assistant Administrator for the Office of Enforcement and Compliance Assurance at EPA. She has a deep understanding based on that those experiences of environmental compliance and enforcement. And that's reflected in her very important new book, Next Generation Compliance, Environmental Regulation for the Modern Era. So with that, we welcome Cynthia to our program and welcome her to our helping us at INES strengthen enforcement. And I want to start with a question that really goes back to why this book? What's the origin of the book, and where do the ideas related to next generation come from? Cynthia?
Well, thank you, Lee. Thanks very much for inviting me. And I also want to thank you for the leadership you have shown over the years in supporting innovative ideas in environmental compliance. Really terrifically appreciated. And I also want to say at the outset that I wrote this book before I returned recently to work at EPA. And I am appearing here in my personal capacity, not as a government employee. And the ideas that I'm going to talk about here are my own and don't necessarily reflect the views of EPA. So as to your question, the deep origin of the ideas in this book came from the many different positions that I've had over the years. Running a state program, doing individual enforcement cases, running an enforcement program in EPA region, NGO, as the AA for enforcement, as you mentioned. I've seen a lot of violations. At the same time, I was hearing from many people, it is just commonly stated, industry, government, NGOs, lots of people say that compliance with environmental regulations is pretty good. That's the common wisdom about compliance, and that was not matching with what I was observing in the field. So when I came to EPA in the enforcement office, I asked folks to, what do we know about the state of compliance? And I did a lot of my own research for writing this book. And what I observed is that serious violations are widespread in environmental programs across all types of programs, all sizes of companies, all types of kinds of violations. And I've asked lots of people over the course of my career to guess, what do they think the rate of serious noncompliance is with environmental rules, including these are professionals who've spent their entire careers working in environmental protection. The most common response that I got, people's estimate was maybe 5 to 10% of companies have serious violations. Nowhere close. That's nowhere close. The norm is 25% serious noncompliance, not just any noncompliance. These are the violations we care most about. 25% is a norm. Many are much higher than that, much higher than that. So the origins of this book were me discovering that the evidence does not support the assumption that in compliance with environmental laws is good. And then I set about saying, well, what can we do about that? So that's the origin.
So why do you think that perception gap exists? That's a pretty major gap between
Yes, it
5
is.
and 25%.
Yeah, and I just want to point out 25% is in most situations the best case. There's lots that are worse than that. There is a deeply embedded belief system, both that compliance is pretty good and that it is the job of enforcement to take care of the noncompliance. So those two beliefs are why it's hard to even articulate how widespread those are. I mean, everyone just thinks takes those as given. That's just the way it is. The focus of the book is how can we do regulations differently to lead to a much, much better outcome. The people who are involved in writing regulations, because they have the view that compliance is pretty good and that it's up to enforcement to make sure it is, they don't see the noncompliance problem as being their problem, as being part of the regulatory the issues that the regulators, people who write standards need to address. So they're just so deeply embedded, those beliefs. And I'm hoping that my book, and the evidence that presented there, the exhaustive evidence about the noncompliance will help to turn the tide on that.
Well, isn't that in fact the job of enforcement to take care of violations of the law, or is that asking too much of enforcement?
That's the second belief. So the first belief is compliance is pretty good. The second belief that it is up to enforcement. And that is like the belief that compliance is pretty good. That belief that leaving it up to enforcement is the way to go is also wrong. It's also wrong. The evidence shows that it is the design of the regulation and the extent to which that regulation builds in drivers for the good compliance that determines the compliance outcome. Enforcement is important, but enforcement alone cannot fill the compliance gap created by a rule of bad compliance design. I do want to say, and I'm sure the folks listening to this, a lot of whom are, professionals in this arena, understand this, but I just want to underscore that compliance is not all or nothing. So, some companies partially comply, or they comply part of the time and not at other times. What the book focuses on is the most serious violators, the pollution, the requirements to avoid pollution issues. Are the thing that I'm focused on, and not just any old violation. So the 25% significant noncompliance that I mentioned is for the serious violations. So those are the dual beliefs that gave rise to the situation that we have now, with many regulations not achieving the objectives because of such extensive noncompliance. The dual beliefs that compliance is pretty good and it's up to enforcement to address them, I think are demonstrably wrong. And the book addresses why and shows what we can do about it.
So the kind of idea is that enforcement needs to be there. It needs to play a role, but you can't ask it to play as big a role as regulators may be asking it to do, perhaps unwittingly asking it to do.
Well, the rates of noncompliance that we're seeing in the world that are documented in the book have arisen under the framework that says it's up to enforcement to take care of it. So the evidence shows that depending on that pathway alone is not going to get you there. Plus, logic and common sense show us the same thing, because there's a handful of enforcers at the federal and state level, and there are millions of regulated entities. It is completely impractical. And the book goes through lots of specific programs and the information and data. It's completely impractical to expect that we're going to be able to have enforcers assure widespread compliance. Enforcement is very important for the unexpected and the egregious and criminal behavior. Enforcement is very important, but depending on it to do the basic job of assuring widespread compliance, that's not going to be possible.
So I assume that that is the very reason that you focus on rule writers. That's why you think rule writers need to pay more attention to the enforcement side and not just look at how to design a compliance program.
Absolutely. And I would say it's broader than looking at enforcement. I think that compliance is another word for implementation. So what we care about is what happens in the actual world. We don't care about just what's written down in the standards. And the rule writers care about that too. So what rules are attempting to do is get a change in behavior in the world so that we better protect health. So, what happens in real life is another way of putting compliance, like what actually happens in the world. And why does that matter? Well, if you look just in the US, there are 130 million Americans living in areas that do not meet the health-based standards for air quality. 50% of water bodies don't meet water quality standards. Go on and on. There's lots of other programs with similar statistics. And I would add that compliance is central to environmental justice. Because the burden of all these violations is not equally distributed. The burden falls more heavily on disadvantaged communities. So it's the message of the book for regulators is you need to think about what's going to happen in real life when you're writing standards, and you need to design your rules so that you will actually achieve the objectives you're setting out to achieve. And depending on enforcement to do it all is not going to work. So
could you give us an example of an illustration of a rule where compliance is built in and how that helps with that real world situation?
So yeah, I thank you for that question, because my experience has been that examples are the best way to explain the concepts that are the next gen ideas that are in the book, to show people how it actually works in real experience. So one terrific example of a very well designed compliance rule is the acid rain program. So for folks who aren't aware of what that is, the sulfur dioxide emitted mostly from coal-fired power plants, many years ago, was responsible for causing actually acidic rain across large swaths of the United States. And there was also a lot of public health impacts, but this program was directed to the acid rain issues. And Congress said, okay, you got to fix that. You got to do something. And here's the design of the program that was incredibly effective. 99% compliance, which is, practically never does one achieve a compliance rate of that level. So here's what they did. First was continuous emission monitors. So monitors in the stack so that you could know in real time, actually measure how much SO2 was being emitted. Don't guess, don't estimate. actually know. Then to inspire the companies to actually use those monitors and make sure they're working right all the time. A provision that said, if you have any missing data, if your monitor's down or it fails QA/QC, you are not going to have missing data. We are going to assume a level of emission from your facility, which is probably higher than you actually had. So that provided a good motivator for the companies to maintain their monitoring. Electronic reporting, which was a comparatively newer idea at that time, and still unfortunately isn't always the case. Electronic reporting, so that the agencies could have the information in real time and do data analytics with it. And then a underappreciated important quality for rule effectiveness: simplicity. So even though the rule is somewhat complex in terms of the obligations for monitoring, it was all boiled down at the end to, do you have one allowance for every ton of SO2 you emitted? Yes or no? It was really easy to figure out who was complying and who wasn't. And then the last thing is automatic penalties. So if you don't have enough allowances at the end of the year to cover your tons emitted, you owe a penalty. And that penalty is higher than it would cost you to go out into the market and buy an allowance. So why wait and pay more? It's cheaper just to comply. So it's the interlocking nature of these pieces that really had such a terrific compliance result for this rule. And I would note that this is a cap and trade rule, a market type system rule. And sometimes you hear people citing it as evidence that market systems produce good compliance. No, the market system helped to reduce costs, but that is not what was responsible for the good compliance. It was these mandates contained in the rule, the interlocking mandates, that produced that terrific result.
It's interesting because I was involved with ELI in 2001 in a study of implementation of the acid rain program, and we visited many electric utilities around the country that were subject to it. And one other, I think perhaps coincidental value of the rule design was that it fit the business model of electric utilities. They were used to buying and selling commodities, and so they could drop the cap and trade program right into their business model. So that also, I think, was a helpful feature. But the certainty and the penalties clearly were an important aspect of that program. It's the most impressive one that I'm aware of. What about examples where design went wrong or didn't produce good enforcement results?
So I would say a good example of a compliance disaster is new source review for coal-fired power plants, and it's a good example to juxtapose next to acid rain, because it's the same sector and the same facilities. So it's not something unique to the facilities. It shows how rule design, how important it is. So what this program was Congress, seeing the huge amount of air pollution that was a big problem across the country, said, we've got to change that. And EPA, you got to write standards to modernize air pollution controls. And they will be required for all new plants. They will not be immediately required for existing plants, but they will have to be installed as those plants update and upgrade their facilities. These were very big deals. So these pollution controls reduced pollution of the, these very important for protecting public health, reduced pollution by 95%. I mean, they made a huge difference, these modern controls. But so for the new plants, okay, that was all very clear, proceeded as planned. For the existing plants, the design of the program had a very different outcome. And I would say the design of new source review for coal-fired power, there were other sectors covered too, but just focusing here on coal-fired power, was a perfect storm of bad compliance design. This is, if you set out to design a program that was going to have bad compliance, it would look a lot like this. So why is that? One is it was very, very complicated rules for when were the modern, when did you trigger the obligation to install modern controls? Very complicated. And they were facility specific. So each one was very fact intensive and driven by the circumstances of that individual plant. And there were almost no reporting required. So companies made the decision behind the scenes as to whether they thought the modernization they were doing at the plant triggered a new source review or not. And it was very hard for EPA to find out, figure out who was violating. It took a lot of investigatory work to figure that out. And then you couple that with the fact that these controls were very expensive. Hundreds of millions of dollars was not unusual for an individual plant. Worth it because of these gigantic pollution reductions that modern controls allowed and the big public health benefits from that. But the reason that's relevant is that it motivated the companies to find ways to avoid having to meet these requirements. And the rule design gave them lots of ways to do that. And the net outcome of that was, with EPA's subsequent investigations, about 80% of the top 25 companies running coal-fired power plants were in serious violation of these rules, serious violation. And I just want to underscore again that this is the same sector that complied so fantastically with the acid rain program. So observing that, EPA decided, like 20 years ago, EPA decided, well, we can't have this. These modern pollution controls are absolutely essential for public health. And so we are going to go after these facilities one at a time. And that's what EPA started doing like 20 plus years ago. And trying to get courts to order companies to comply with these standards. So that's a long and expensive project to try to get compliance with the enforcement one at a time.
Yeah, it sounds like enforcement played a significant role in sort of catching up on the grandfathered plants, but it sounds like what happened in the process is that a tremendous amount of enforcement resources had to be diverted or focused on these, perhaps to the expense of other important issues which might have been able to be focused on had the rule been designed better.
Yeah, absolutely the case. And I would say the new source review enforcement history and the 20 years of litigation that has resulted is really the exception that proves the rule of what I'm saying in the book. There's a large but a limited number of coal-fired power plants. Most sectors regulated by rules that EPA does are in the hundreds of thousands, in some cases millions. It is obvious that you cannot do a one at a time compliance strategy with sectors like that. Over 1 million oil and gas wells, hundreds of thousands of drinking water systems, for example. It's just not feasible to do that. And as the new source review enforcement history shows, not only does it take a lot of time and money to do it, in the meantime, you've lost all those years of compliance. All the benefits for public health that were intended to be achieved are long delayed while all this litigation goes on. We would never pick this as our plan. Nobody who's writing a rule says we're going to set a standard and our plan is enforcement is going to sue everybody one at a time. Okay, that would never be a sensible approach to how you're going to implement your rules. So while it was worth doing and that was the right decision to do it in that case, it could have been avoided with a much more well-designed rule that didn't require the one at a time litigation.
So you've had experience with a lot of different rules over in state agencies and the federal level. How typical is rule design a problem with compliance? And are there some examples of the types of barriers that you might see as common among rule design that need attention?
Well, there are tons. There are many, many, many examples of this. When we look at the record about non-compliance and see how incredibly widespread serious violations of the rules are, it's not just New Source Review. There's lots of other examples. Here's another one. There has long been, historically much worse, it's much better now, long been a problem with discharge of raw sewage in the waterways in cities around the country. Yeah, that's really bad in terms of exposure and public health threats. Exposure to raw sewage is a big issue. 97% of large cities were in violation of these standards in the Clean Water Act. 97%. Okay, so practically nobody was complying with those. There's lots and lots of other examples that are, sort of shocking levels of noncompliance in the book. It's also the case, though, that for many environmental programs, because of this background idea that compliance is pretty good, enforcement will take care of it, there's lots of programs where we don't know how we're doing with compliance, where the signs are not good, but we really are not sure. So discharge of contaminated stormwater with all kinds of chemicals and stuff and runoff included. Oil and gas wells, lots of indication of a lot of violations, but we don't really know the answer. Pesticide applications that expose farm workers, lead paint. I mean, the list goes on and on. And these outcomes are really not acceptable for these environmental programs. We set out to protect public health, and we need to do that. So after this case is laid out in the book, the rest of the book is about, okay, so what should we do? What are the design elements of a rule that will give us different results?
I want to go back to something you mentioned briefly, and that's the kind of frequency with which enforcement programs are able to inspect facilities, for example. So I remember a study by the state auditor in Minnesota on small quantity hazardous waste generators. And the auditor said outside of the metropolitan Twin Cities area, a small quantity hazardous waste generator might be inspected once in every 20 to 100 years on average, given the fact that for the whole state of Minnesota with nearly 5 million people, there were 18 inspectors for the entire state to do that work. So how do you see, I suspect that this issue of personnel and the ability to inspect plays right back into the rule design question. You need to find a way of minimizing the workload on the agency personnel who are available to do this.
Absolutely, Lee. So when people dig into the data like you just did there with small quantity generators, which is just one program out of many that states and EPA are charged with implementing, it is obviously untenable to count on doing inspections as your main means of driving compliance. Okay, that's just not going to happen. And so there's lots of other tools that can be employed so that the limited number of folks who are available to work on enforcement can focus on the things that enforcement does best. Like criminal enforcement, going after the most egregious violators, unexpected problems, emergencies, things that are outside the norm that enforcement has the tool and the speed to respond to, not the basic job of achieving overall compliance. I just want to make sure I'm very clear. I know you know this, but I want to make sure I'm very clear. Sometimes when I talk about next gen, people think I'm saying enforcement is not important. No, no, I am not saying that. Enforcement is essential to a solid compliance program, civil and criminal. What I'm saying is enforcement alone cannot be responsible for achieving widespread compliance and will never be able to close the gap that's created by badly designed rule.
So with that, as you suggested, maybe we can turn to some of the solution side of your observations, and talk a little bit about what are some of the next generation strategies you think can make a difference in relieving some of the workload on enforcement personnel and producing compliance without having to turn all the time to enforcement. And I do note just that we do have a few questions now starting to show up on the Q&A. We'll reserve those for a few more minutes, but let's turn to solutions.
So the best design is a design that is made to suit the particular problem. There's not a one-size-fits-all answer. Obviously, the way you would assure compliance with a standard to reduce exposure to pesticides is different from what a coal-fired power plant would be expected to do, which is different from lead paint. So there's not one answer. And I want to also underscore, it is not about making rules enforceable. Of course, they should be enforceable. Why do you have one if you don't have that? Yes, they should. But this is going way beyond enforceable to how do you make compliance the default? So while the best design is suited to the particular problem, there are some strategies that are widely applicable across all types of problems and make sense to consider when you're tackling your specific issue. Here's a few examples. Measurement is key, fundamental, and monitoring for pollution is getting better, cheaper, more mobile, more accurate. We have now possibilities of monitoring through satellites, for example. Direct measurement is almost always the best way to make sure you know what's going on. Give you one illustration. EPA often found going into the field when they did direct measurement that it was vastly different than what people had been assuming. So like with refinery flares, for example, hazardous air pollutants from refinery flares, EPA found with actual measurement that the actual amount released was 25 times the amount that was being assumed. So obviously that's a giant issue for the host communities. So pollution management is one thing. There's all different kinds of measurement, not just pollution monitoring. Measurement, a key strategy. A second one I would say is transparency. Transparency can be really powerful in the right instance. Here's an illustration. For the drinking water program, there was required what they called consumer confidence reports, which is basically just a statement to all the people who bought the drinking water and consumed it. How did your drinking water provider do complying with the health standards and the Clean and Safe Drinking Water Act? And a really terrific study found that just having those reports motivated the drinking water providers to improve their compliance with these health-based standards by between 40 and 57%. That's an incredibly powerful compliance driver that came just from requiring these reports. Another example is IT solutions. It's not all about monitoring and think about pollution. Today's IT environment provides so many opportunities for creative ideas. Here's an example. HFCs, which are a very powerful climate forcing substance, US is doing, Europe has been doing for a while, trying to get a grip on and reduce the amount of HFCs being produced. But as Europe has been experiencing, as they've ratcheted down, there's gigantic quantities of illegal imports were coming into the country, significantly undermining their ability to reduce HFCs. So what did the US do? In seeing what's going on in Europe and wanting to have a different outcome in the US, real-time checking at the border. So products that are coming in will be able to check in real time. Customs can check in real time whether the importer has sufficient allowances to cover that import and deny entry if not. So reduce the supply of illegal imports, and then a QR code on every product, which taps into a database, tracking database that EPA is going to monitor, so that anyone can know by looking at and a quick scan of the product, is this a legal product or not? So that's a powerful way to reduce demand for illegal activity. So that's just one illustration of many, many ways to use the power of IT to approve compliance. And then I can't resist adding again the very important element of simplicity. It's impossible to overstate the importance of simplicity. A good design can make even a complicated problem comparatively simple, as acid rain did, for example. So those are a bunch of things. There's lots of other scores of ideas in the book. Those are just some. Here's what will never work, and which is most commonly done, which is write down a standard and then hope for the best. Count on the honor system to assure compliance. We all know from our personal life experience that the real world is messy. Things break, budgets are tight, companies have other priorities, incompetence is everywhere, and some will just cheat. Of course, that's to be expected. Relying on the honor system is doomed as an implementation strategy. Not saying the companies want to violate. Most of the time, that's not the case. But they are not doing what's necessary to comply.
So you mentioned briefly monitoring, and of course, there are a lot of new advanced monitoring technologies, handheld technologies that not only government but citizens have access to. Do you have some thoughts about how enforcement folks should think about kind of interfacing with the data that might come from citizens on some of these, and how that might play back all the way to rule design, for example?
Yes, I think that is an incredibly powerful and underutilized tool. There is a lot more information available out in the world than government has direct access to. And this is a part of transparency strategies are actually based on these kinds of opportunities for third parties to participate. Because one of the theories about making some kinds of data available in a targeted way, very intentionally, not just blasting it out to the world, but making information available, is a way of sort of crowdsourcing compliance, so that you can get lots of citizens, other companies, other government levels, taking a look at the data that's being submitted and is available to say, hey, you know what, this doesn't add up, or this is not consistent with something else that I know of in the world, or I have monitoring data that says otherwise. That's tapping the power of citizen involvement, and more broadly than. When you say citizen, most people think individuals, but using that term broadly to mean NGOs, other companies, other governments.
Yeah,
very powerful.
Yeah. And universities often have
universities
a lot
too,
of
yes.
that data.
Very much so.
So we've got two more questions that I wanted to ask, and then I want to turn to the questions that have been submitted by the audience. I think we have a dozen or so. Do those next generation ideas, how do they apply in different contexts? And then maybe even if you have some thoughts in different countries.
I think the concepts apply everywhere, which is design it in. Don't count on something happening afterward. Build it in so that you actually get the result you're looking for. The concepts apply everywhere. The strategies may well vary. It depends on the what will motivate companies to do to more closely align what they're doing with the public interest that's reflected in the rule. Depends on the circumstances. So public pressure, for example, the part of the concept behind transparency, public pressure actually, I think, has more effectiveness in more places than many people may think. For example, in China, there's been some really interesting work about how transparency in environmental arenas is driving better pollution outcomes. It's not, I just want to underscore that, like any other aspect of rule design, it has to be carefully designed. Transparency of just saying, let's post everything on the web is not an effective strategy. You need to design your transparency to address the specific way that information might affect the outcome. Another illustration is in India, there was a really creative study done about the ways you could design third-party auditing to have much better outcomes. They were able to do in India something that would be tough to do in the U.S. Without a specific regulation. But that's an illustration of how different countries can experiment with designs that work for their setting. So my experience has been that regulators know their setting. They know what the pressure points are on the companies. They know what the sort of government structure and the public ethos is that will matter. And if they design the solution to the problem and the circumstances that they are in, there is always some way. It's not all high tech. There's often some low tech things that can be done. If the regulators think carefully about what's most likely to cause the companies to do it, and what are the most likely barriers, and how can they get over those, I think just about always possible to put some things into the regulatory program.
So we'll wrap up my questions, at least, with asking you what some of the key takeaways from your book are. If you could say 3 or 4 things that are really important, what would they be? And then we'll go to some of the audience questions.
Okay. Well, I would say one is don't accept the view that companies will comply just because it's required. Many environmental, there's lots of places with tough rules, but they're not seeing the change in the world that their tough rules were designed to affect. So I would say, don't accept that. Understand that if it's easy to evade, avoid, obfuscate, lots of companies are going to do that. And it's on you as the regulator to design something that will prevent that. Likewise, don't accept that enforcement is the only answer. You need enforcement, but there's lots of other tools in the toolbox. So don't divert all your effort to building up enforcement at the expense of these design principles. Be pragmatic. Next gen ask only one question: will it work? The setting and solution will vary, but the idea of designing it in it applies everywhere. And we can't depend on any program that depends on extensive government involvement. Government's got to be checking this. Government's got to be out in the field doing something. If your program won't work without extensive government involvement, that program isn't going to work. because we all know the reality that, the money, the people, the resources, the political will are not always there. So if you build a program dependent on that, that's probably doomed. So I would say the book is filled with practical ideas. It's all about practical ideas and examples. And let me just mention at the end here, that the book is available for free. It's free. It's open access. You can download the book at nextgencompliance.org. So if you're a regulator and you're looking for ideas, take a gander at that and see if it inspires you.
Should be affordable for most people at that price. So I want to turn to a few of the questions. The first one really focuses on climate change and asks a little bit about the future of environmental regulation as we move towards more regulation of greenhouse gases. What are a couple of the critical design issues that you think are going to be important? And obviously, we talked about cap and trade programs, but translating a acid rain program that regulates 260 or some odd facilities to climate change is there's not a one-for-one there. So your thoughts?
Absolutely. Well, I want to just say I couldn't agree more that the climate change is a very important venue for making sure we get these rules right and that they actually work. And the book devotes a lot of time to addressing how to apply next-gen concepts to climate change. I would say on the specific issue that you raised, Lee, about the sort of market, suite of market type ideas around climate, I would underscore the most important thing for any market strategy, the most important thing, economists, everybody agrees on this, the most important thing is you have to be able to reliably measure the thing you're trading. If you cannot know, whether that thing that's being traded is actually worth what it claims to be worth, your market program will not succeed. And I would say carbon offsets, a popular idea, stumbles on this problem because that is not really measurable. So there's lots of other ideas about how to deal effectively with in the regulatory arena for climate change. But the market one, I would note in particular. And I would say nowhere are the ideas of next gen more important than in the climate arena. We cannot afford to have rules that are not effective in real life. The climate doesn't care about your theory and your papers and your, regulatory philosophy. It cares about are the emissions lower, and we have to get there. And it's important that these ideas work the first time.
So we have a question that focuses on how next gen ideas might best advance environmental justice and community resilience. Do you have some thoughts about that?
Yes, I would say the reality that we face in the United States, that communities of color and low-income communities are significantly more burdened with the pollution problems than elsewhere, is a giant problem that needs attention. And next gen, I think, is part of the answer, because no one knows more than those communities how unreliable it is to have to depend on government at all levels to be responsive to their needs and to jump on these pollution problems immediately. They've observed that, changing political views, resource constraints, a whole variety of things interfere with the ability for that to happen. So these kinds of more self-implementing, effective in the real world, even if you can't do a lot of enforcement, that is a big part of the answer for addressing the the terrible inequality issues we have in America today and exposure to pollution.
There's a brief follow-on question related to cap and trade and how you can design cap and trade programs in a way that doesn't create environmental justice communities for maybe the receiving end of the trades. I know that's been a long an issue with the acid rain program. Perhaps you have a thought about how you protect environmental justice communities in that context.
Yes, a very important question. There are some ways to do that. There are some ways to design market programs and put some constraints around them to prevent that kind of outcome. But I would say, if you cannot design your market program so that it can do that, then maybe a market program isn't the right answer for your issue, because assuring environmental justice is a key part of not just national or global level pollution reductions. Environmental justice is a key part of the drivers for what types of strategies we should consider or not consider for certain problems.
And there's an interesting question about in the US, of course, wastewater permittees have to provide regular reports that are now all electronic, which is helpful about whether there's violations, but the comment notes that there's still a lot of non-compliance reported, and there may not be consequences for that. So they ask, what gives? Do you have any thoughts in that regard?
Well, I think this is a terrific illustration of the idea that there's not one answer in a rule for how to assure compliance. There's not one next gen idea that just is, the golden key solves all problems. Transparency is an element of, but usually not sufficient in and of itself to solve the non-compliance problem. So I think that this kind of electronic reporting and posting the information and making it widely available is a necessary but not sufficient condition for improving compliance. And you need to address all the other aspects in your regulatory design too. So I guess I might add this to the list of ideas, advice for people. I would add this idea. It's not one thing. Okay. You need an interlocking set of features that work together to achieve compliance. It's a compliance system. It's not a compliance single idea.
So it's an interesting question, a little bit off of probably your main area of focus, but the question notes that California, Maine, Colorado, and Oregon have recently put extended producer responsibility packaging regulations in place to address some of the plastics issue. And of course, states have had electronics EPR for some time where it requires the manufacturers to organize take-back. How do you, the question asks, how would you compare their potential compliance effectiveness, assuming you know anything about the EPR schemes in the UK and the EU, or if you have generally thought about these kind of manufacturer take-back programs and compliance?
So this isn't a topic I know much about or have spent a lot of time thinking about. So I don't know the answer. I don't have an informed opinion onto that question, but I would say one thing that your question illustrates is the value of states and various governments taking a stab at trying something, trying to develop a strategy and see how well does it work. We all learn from the innovation that different governments show in designing their regulatory tools. Many of the ideas that I talk about in the book are, what have we learned from, states tried this, states tried that, US tried different things. What have we learned? You learn just as much from the failures as you do from the successes.
So we have also a question about how do you build the rule writer skills that that are so clearly needed, and how do you suggest that the rule writers interact with the enforcement folks so that you can build in better compliance into rules?
That is a very important and challenging question. One of the things I'm doing is just by being a giant pain in the neck and keep raising these topics all the time in the rule writing context. But beyond that, one of the things the book suggests is that within the context of the US, we need to have an obligation imposed on rule writers to consider real world implementation in the design of rules. It should be a necessary, just as we do, benefit cost analysis, and just as we do, survey the literature on controls, there needs to be the same type of rigor applied to making sure that these kind of implementation drivers are contained in the rule. We learn from next gen, the next gen ideas apply within government too. Big change doesn't happen. People don't jettison, deeply entrenched beliefs just because you say, wouldn't it be a good idea to? So we need to have kind of structural design things built into the regulatory process that insist on these topics being looked at. And if you have that, and if people have to do it, then they're going to start looking around like, where's the evidence? What should I, and that by itself is going to be a big driver of change.
We've got time for a couple more questions, and one of them comes from someone very familiar to you, David Hinden, who
Hey,
says, perhaps one common design is clear applicability so that the regulated entities, government and public, know who is regulated. Lots of exemptions, adjustments, and exceptions about who is covered, under what circumstances, when they are covered seems too common. Yes, what's your reaction?
Well, obviously, I totally 100% agree with that. 100% agree. And the new source review example that we talked about at the beginning is an illustration of how all that mess and complexity can lead to significant noncompliance. Yes, simplicity in all features, applicability is one. Simplicity is a powerful part of a better compliance. You need to start with making it clear who's supposed to do what. If you're not clear about that in a rule, that your chances of actually achieving your objective are going to go way down.
So I've got probably time just for a last question. And this also comes from someone you're familiar with, Patrice Sims.
Hi, Patrice.
And Patrice says he has two questions. Compared to the acid rain program, how do technology advances make next generation compliance even easier now, both information technologies and monitoring? And what is the role of NGOs to help drive these changes?
They absolutely do. So the advances in both monitoring and control and information technology that we've seen, I mean, it's really the revolution that we've seen over the last 10 years and what's possible makes so much more ideas and strategies available to rule writers than used to be the case. So we really do not need to depend on inspectors going to facilities as was done, at the beginning stages of the 1970s when we started out. Yes, that's still important to have in many instances, but there's lots of things we can do that to expand our knowledge about what's happening and apply pressure and create solutions with these new technology designs. And the book talks quite a bit about that. And I would say NGOs are, have been and will continue to be a central part of making that happen. Couple different ways. One is NGOs are among the best consumers of transparency information and figuring out, finding the signal and the noise in that information and bringing that information to light and drawing attention to it, which is a powerful driver for change. NGOs have always played and are playing now a key role in doing that. And I would say NGOs can also help by when they engage actively with all levels of government about permits, about regulations, about the policy choices that are being made, to raise this point. How do you know it's going to happen? What's your method for assuring that it's actually going to happen in real life? We want to see evidence that it's going to really happen. That will be also a powerful driver for governments to pay attention to these issues.
Well, we've come up on 10 o'clock here in the East, and the end of our time. I first of all want to very much thank Cynthia, and do take the opportunity to acquire her free book. It is really an excellent resource. And also just quickly point out 2 upcoming INEAS events, both of which don't have a specific time yet, but we are going to do a enforcement technology webinar towards the end of April or May, early May. And then over the summer, we hope to do a webinar focusing on enforceability of climate regulations and statutes, which we have hope will be able to bring Cynthia back to be part of that program. So thank you all. I appreciate your taking the time to join us today, and have a good day.
Thanks.
Thank you, Cynthia.